Record. All right, we're recording. So hi, everybody. Welcome to December's SDE session. My name is Julia Petrie from Search Discovery, and I'm very excited to introduce you to our guest speaker today. So she has a great presentation planned, but before we get started, I'd like to remind you to use the Q&A function here in Zoom to submit your questions, and we'll make sure to get to those at the end of today's session. So with privacy being such a hot topic with so many conversations taking place, our guest speaker today will be setting the story straight by debunking the top 3 privacy myths. She is a certified informational privacy professional, national keynote speaker, co-author of the best-selling book, Data Reimagined, Building Trust One Byte at a Time. She's a featured professional in The Economist, Forbes, and many others. And she is the founder and CEO of Red Clover Advisors. Today's guest speaker is Jodi Daniels. All right, you can take it away.
Great. Well, thank you so much, Julia, and delighted to see everybody here today. So thank you so much for joining us. We are all about making data privacy simple, and that's what we're going to accomplish here today. And the way that we like to look at privacy is to kind of break down these big laws into core requirements. We kind of built our privacy ops framework. We look at establishing governance. Maybe that's you. Maybe you're curious about privacy. And there's internal policies, external policies. There's this idea of a data inventory, understanding all the data in your company. You might have been a part of a privacy impact assessment. That's a fancy word for just understanding what's actually happening in an organization and the risks from a privacy point of view. Individual rights, do not opt out of Search Discovery's awesome emails. That could be an individual right, but don't do that. Vendor management. Do you know all the different vendors in your company and how they're being used? Marketing strategy. We're going to spend a lot of time on talking about how marketing and privacy relate. There's a long list of requirements. Security. We got to protect all the data. True story. I know of a company this morning and the individual's computer was just hacked. Now they can't run their company. Training. What is it that you need to know about privacy? And rinse and repeat. That is a lot of stuff that we do all day long at Red Clover. And here today, we can only talk about a few of them. But I wanted to kind of set the stage with this framework about how we like to look at privacy in the context of what we're going to be talking about here today. Because again, we only have a short time together. Now, with that being said, I'm not a law firm and I'm not an attorney. So my fancy disclaimer is this is not legal advice. Now, with that out of the way, it's really important to kind of understand where we're going to go with debunking our 3 biggest privacy myths with understanding where we are from a privacy law point of view. Now, for some, this might be old hat. For others, this might be new. We will have 5 state privacy laws that will be in effect by the end of 2023. First up, we have California. You might say, well, we already have a California law. It's called CCPA, the California Consumer Privacy Act, but it got an upgrade called CPRA, Consumer Privacy Rights and Enforcement Act. CPRA kind of raises the bar. It makes it closer, but not quite to GDPR. And those CPRA changes become effective in January. It will become enforceable in July. Then we have Virginia. Virginia passed a privacy law. It's called VCDPA. VCDPA. And that becomes effective in January as well. Then we have Colorado and Connecticut, which will be in the middle of the year, July, and Utah at the end of the year. Of course, maybe you and your organization have already been complying with GDPR. We have the EU version and the UK. There's many more. Maybe you are in Canada, in China. There's literally over 150 privacy laws. You might be thinking, oh my gosh, that's a lot of privacy laws. Or maybe we're going to get ready for myth number 1. All of those laws in the United States have floors, because here in the US, we like to help the small business. And as a small business owner, I'm really appreciative of that for a variety of different laws. But at the same time, I know if I want to act as a good business, if I want to attract talent, I'm going to need to do things above and beyond the baseline. Globally, there are no floors. Globally, there's no revenue floors. There's no, depends on how many people you have. So myth number one is that the laws only apply to the big companies. And we're going to really dive into that. I wanted to set the stage for those big 5 privacy laws because, as I just said, it matters from a US point of view to decide, is it specifically in scope for you? Because the US has either revenue thresholds or the number of people that you're processing in that state threshold. But again, if you are serving people outside the United States, you might be automatically in scope. And we're going to talk about some of the other reasons why this is a myth. So number one, what do you need to do? You need to understand who you're targeting. Where are your customers and prospects? The laws follow the people, not where you, the company, are. I still get companies all day saying, well, I'm based in Georgia, so I don't have to worry about California. Or I'm based here, my customers are in the US, I don't have to worry about those people in the EU. If you are a B2B company and all your customers in the United States, that's lovely. But the data of your customers could be global. Your customers might expect you to comply. It's critical to understand where your customers and prospects are. And again, if you're in the B2B space, where are you serving? Where are your customers coming from? Then you do need to look at those revenue thresholds, and they do vary by state. But often it's about $25 million in revenue, global revenue. You could make $1 in California. Or the number of personal information you're getting on people in that state. It sometimes could be 50,000. It might be 100,000. It really just, you have to look by state. And then maybe you're in the financial space or the health space. So you kind of have to just look at, do you have exemptions? Some are by, some states exempt the whole entity. Some states just exempt part of the entity. But what is really important here? Because a lot of times people will think, I'm too small. I don't have to worry about it. And technically speaking, you might. Maybe you're listening and you're a $10 million company. Maybe you're a $20 million company. And you say, oh, phew, I don't have to worry about it. But here's the thing. What do your customers expect from you? What do your investors expect from you? And let me tell you a little bit about what consumers think. This is a very consumer-centric approach, but we have 68% of consumers who are uncomfortable with their online data being used for advertising purposes. Just about everybody. There's, like one person out in the universe who doesn't seem to care about privacy online. So 99% of consumers agree privacy is really important. And the last stat I think is also really exciting is as we move away from cookies and we'll rely more on first-party data, I'm going to need that first-party data to be accurate, because otherwise I'm going to be making decisions and analyzing data that's inaccurate. That will affect all of my marketing, my results, and everything about it. So only 34% of people are willing to share their data for a personalized experience. If we want to increase that number, we're going to have to convince them that they trust us, that we are a safe company to give accurate information to. And even if you're too small or you don't have to comply, maybe you don't do business in a particular region, so you can kind of exclude them. What do your customers expect? Fun fact, I'm based in Atlanta, Georgia. I don't have to get a cookie banner. There's no law or rule that I need a cookie banner. However, I get them all day long because companies, either one, put them up and didn't know what to do, so I just happened to get them. But many companies purposefully put it up because they want to make it consistent for everybody, because they know what customers expect and they want to be transparent and opt in that direction. Now, before we go to myth number 2, I want to just take a really quick pause. And if you can just put your answer in the chat and tell me, where are you? Do you have a B2B environment or a B2C environment is question 1. And question 2 is maybe just say the industry that you're in. Are you in the retail industry, health industry, technology industry? I just would love to get a sense where people are. So I'm going to take a moment and put that in the chat. We have one who's consulting. Anyone else? Both B2B and B2C, tech, software, and services, media. Wonderful. Okay, just really helpful to kind of get a sense for where we are. Thank you to those who have participated. All right, we're going to move on to myth number 2, which is that everything is opt-in. Everything just has to take an opt-in approach. And I've seen many companies in talking with them, they'll say, well, I have to make my cookie banner opt-in. I have to make all my email opt-in. I have to make everything opt-in. And while that might be a really great approach, it is actually not required. In the land of cookies, there's different kinds of cookies. So here are some of the key cookie groups. Sometimes people extend them. They might list social media and advertising and a few others. But in particular, strictly necessary cookies are cookies that you don't have to opt in. Those are ones that you need to make the site work functionally. Now, sometimes people want to put analytics and advertising in there and say, well, I have to have those. Those are business requirements. And unfortunately, they're really not business requirements. There's been significant guidance out there to indicate as such. So when you think about all these different kinds of cookies, we also have, email laws and things along those lines. This is just kind of a chart. These are all the fancy acronyms that are up at the top for the different laws that are really common that we tend to look at all day long in our business. And you can kind of see the diamonds which show opt-ins compared to where there's no opt-in, which would indicate you need to think about what will work for you, because not all cookie requirements are created equal. I mentioned Jodi in Atlanta gets a cookie banner. Well, how that cookie banner is actually functioning is different. You might give me the option to accept and reject. However, you technically could fire the cookie first, and then I can reject it. If Jodi now has moved over the pond and I am in the UK or in the EU, you cannot do that. It must be an opt-in approach first, then allow me to make my preferences and decide to opt in. So very different approaches. And globally around the world, it is a little bit more of an opt-in approach. I'm seeing a lot of companies, people always ask me, which way should we set it up? And I really don't have a good answer in terms of what's consistent, because it's not. Everyone is just taking what works best for them and their marketing goals and applying them. But it is important to understand where your customers and prospects are by region. And I highly recommend doing a cookie audit. I once worked on a company, they had 20, 30 different websites, 20, 30 different cookie experiences that were all wrong. There wasn't a single one that was doing it right. And they had never done a consistent review of what they had. And now going forward, they were able to move forward with a plan and make them consistent. So I highly recommend you understand where you operate, your regions, including the states, and then do a cookie audit. Now with cookies, I think you can have some fun. I just have a couple examples here so you can see. The first, I have Starbucks. You can kind of see their example. This is from the app. They're really trying to connect their brand and their voice. This other one is just nom 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 cookies, right? Just trying to have a good experience in doing so. You also can have different types of cookies. Here's one in the corner. This is Ann Taylor, where it has just a little bit of a pop-up. And you can kind of proceed from there. And then this is just a Fox, just like Fox.com. And I pulled this in so you can actually see very specifically for do not sell. And we're going to talk about do not sell in a moment. But I wanted you to be able to kind of see, their experience here as well. Now, when you're working with cookies, you want to make sure that you understand the banner in the language in both your privacy policy and in the cookie experience needs to be specific. You need to say what kind of cookies you have, highly recommend. There's a plethora of cookie tools out there. There's also some great leaders that are available. Make sure you describe what you're doing and the kinds of cookies and give people the options to be able to manage those cookies, make it easy. You want to make sure you have a link in your privacy policy, and you just can't have a banner that says we use cookies. Even for Jodi in Atlanta, who doesn't require a cookie banner, don't just have a banner that says, hi, we use cookies. That's a terrible user experience. And I know you don't care about me. You just think you put it up. And I know you didn't even put it up right because no one else would do that. You haven't given me enough information about what kinds of cookies and why you're using them. I don't need to know that you just have cookies on the site. That's not a privacy forward experience. That's not building trust with me. Myth number 3 is creating a one-size solution that covers all privacy obligations. This is probably the request I receive the most from companies. I need to comply with privacy laws. We're a global organization and we just want to do everything to meet one. Why does that not work? Well, the first example is our friends at Sephora. I'm just kind of curious here. Can we have in the chat a yes or a no? You are familiar with the Sephora case? Yes, no. Okay, thank you for voting. We have a lot of yeses, but we do have some nos. The Sephora situation is they were the first company in the United States to have a fine under CCPA. They were the first to have a CCPA enforcement action. And what happened? Well, they were using a variety of different trackers, collecting information and data. They shared that with third parties. And ultimately, that was deemed a sale of data. And Sephora did not comply with the sale of data requirements. They also didn't do something called global privacy control. And we're going to talk about that in a moment. As a result, they had a fine. They have a consent order. They have to do a long list of things. They have to have reviews every couple of years. They had to change their privacy practices. They have to review every single vendor. There's a long list of requirements they have to do in addition to the fine. And then this is actually inexpensive compared to the legal and outside consultants and fees they had to spend to get to this fine. If they had just complied with GDPR and had an opt-in approach, they may have avoided this, but not necessarily, because GDPR doesn't cover this sale of data as specifically as CCPA calls it out. As an example, here is the actual definition from CCPA for selling and sharing. If you look at the end of selling, you will see it has for monetary or other valuable consideration. And since most everyone in the United States has some type of tracker on the site and is utilizing a plethora of them to share data and is utilizing, all those trackers and the data is going back and forth, ultimately, ad tech is basically being considered a sale of data under CCPA. And so had they really taken the, I'm just going to comply globally, they wouldn't have really had this call out from a sale of data, and they didn't have the sale of data requirements. And most people are not eliminating all trackers in the United States. I really haven't found a company yet that has eliminated them here in the US. They're really taking more of globally, they're going to have opt-in, and in the United States, they'll allow for opt-out. And they have these very specific requirements. What are some of those requirements? You need to have a link to, as I kind of shared in the Fox example, to be able to have a do not sell my personal information link. And there's a long list of other things. You need to have it listed in your privacy notice. And you also, depending on how complex your situation is, there's kind of, the IB just released a new multi-service provider agreement as well. Now, the other thing that Sephora got in trouble for, and is a specific requirement that is not necessarily indicated in global privacy laws, is global privacy control. Several states have indicated they want to see companies having this universal opt-out. And you don't see that happening quite in the same manner internationally. This is a very state-specific kind of thing that we're starting to see. If you have not set up global privacy control yet, I highly recommend that you explore that and make sure that you're going to be on the path to being able to recognize those signals. A couple other reasons not to take a global privacy approach is not all requirements are equal. And you really might want to understand the kind of data you have. For example, sensitive data in California is different than sensitive data under GDPR. And you may or may not want to be as restrictive. We have tons of charts that we're using with our clients all the time of comparing all of those different laws. And so it's really important, if you remember the data inventory that I mentioned as part of a privacy framework, you need a data inventory to be able to understand the data that you have, to then be able to determine what your requirements are. Operationally, you might want to honor privacy globally, but the way your organization's set up, it's just literally going to be an operational challenge to be able to make that happen. And the last thing you'd want is to be able to offer a privacy choice to somebody, for example, and not be able to honor it. Or say you're doing something in your privacy notice and actually not being able to do that. Some organizations really need to have data kept locally, and that might make complying with privacy laws a little bit more challenging. And the other is just your business objectives. Perhaps what your business model is doesn't actually work with being able to make and take the most strict approach that's applicable in Europe if your significant customers and business is here in the United States. You might need to keep them separate. Where to start? That's a lot of information. We just covered 3 myths. I started with a big wheel of almost 10 things to do, but I want to give you some quick wins of where to start. The very first is know your data. Here's just a couple examples of data elements. People kind of sometimes still use the phrase PII, personally identifiable information. We're really moving away from that, really more to personal information or personal data. Technically speaking, those are different definitions. For the general, regular business person, they're really similar. CIP, IP is hanging out here for data elements. That counts. When we think about when we're our browsing history and everything that we're collecting in a digital frame, that counts. That's all personal information. So it's very, very important to understand what you're collecting and how you're using it. It's really important to understand what you're collecting and how you're using it so that you can say what you do and do what you say. The privacy notice is the connection point to explaining to the end customer what's actually happening with all of that data. It's incredibly important. There's long requirements of what specifically has to be in a privacy notice. Here's just a couple. And as marketers, we need to know what those requirements are to ensure our activities match up with that privacy notice and that we can help the team drafting that notice. What kind of data are you collecting? How are you using it? Who does it get shared with? Does it get shared with data brokers? Are you buying from data brokers? What kind of individual rights do you have and how will you be able to honor them? And think about all the tools that you have in your organization. How will you be able to unwind when Jodi makes that kind of request? Specific obligations for CCPA and categories, business purpose, GDPR calls it a legal basis. We have security. We still have do not track. It didn't actually get replaced yet by global privacy control. Children's data, international transfers, how you contact. These are just a sampling of some of the sections that you might want to get started on. Now, when it comes to individual rights, I also wanted to kind of leave you with, see all the diamonds and all the laws again of the common ones up top. They don't all line up. This is sort of going again with myth number 3, that kind of creating a one-size solution covers all the privacy obligations because you may not be able to operationally support everybody's individual rights. You might not want to support that. That might be more volume than your team can handle. And this is just individual rights. If I had shown the same slide for kind of sensitive information, we might have the same situation. So how do we pull all of this together? Well, if we kind of look at what privacy principles there are, it's all about lawfulness, fairness, and transparency. A privacy notice is a long list of required details to basically force companies to say what's actually happening. If you think about every time you're going to do and transact on a new campaign or activity, We want to think about, well, did I tell someone I was doing that? Does that make sense? Would they be surprised? Do I have a business purpose to do this now? Or am I going to maybe collect this data and hopefully use it in some future time? We don't really want to be able to use it in some future time. It needs to be now. That's the future for privacy laws. Collect it now for use now. That's the same idea of data minimization. Do I actually have to have all of that data? Recently talked to a client. Do you really need to have the full date of birth? Or could you just need age range, or maybe birth month, or even just birthday, as opposed to actually the full date of birth? Those are certain examples. Accuracy, understanding the kind of data and making it as accurate as possible, understanding how you store it and securing. And ultimately, it's all about integrity and confidentiality. We're in the trust business. You're trying to get someone to trust to do business with your brand and maintain that. We want to make sure that the company is doing right by its customers, using data ethically and the way that they would expect that data to be used. And of course, to protect that data from a confidential standpoint. What are some great next steps? Understand where your customers and prospects are, because the laws follow where they are, not only where you, the company, are. Figure out which laws are in scope for you. Know your data. If you leave anything today, that's probably my favorite one, which is know your data, because that is the foundation to everything that we do. Highly encourage you to do a cookie and digital tracker audit. Review those marketing practices. Do you know what you have that's opt-in, opt-out? Do you have all the right footer requirements? Do you know what your customers are going to expect from you? My other favorite, send customers awesome, valuable content, and then they'll never execute on individual rights because people who unsubscribe, people who opt out, they're mad at you. They don't like it. So just don't make them mad at you. Make sure everything you do is in line with your privacy notice. That is what you're being held to from a company standard. If you're working with any technology, any tools, any service providers, make sure you have those contracts up to date from a vendor standpoint, because they are responsible too. And we talked about transparency. The other side is choice. Have a process for those individual rights, because those are the choices that people can exercise on. And it's all part of the brand experience. The reality is privacy really yields trust. This is all about individuals trusting companies with data, how they use the data, how they're creating valuable content, what's happening with that data to better serve them. And there's some laws with some very specific requirements, but at the end of the day, it really is all about a relationship based on data. I'm going to wrap now and open it up for some questions. Would love to connect with you. Thank you so much for joining today. Our website's just redcloveradvisors.com. You can find us on LinkedIn. We're also really active there. Emails info@redclovers.com. And if you're ready to learn more and you thought this was really fun, I host a podcast with my husband. We do not work together, but we do a lot of thought leadership together. We have a best-selling book called Building Trust One Bite at a Time. And we also have a top-ranked podcast called She Said Privacy, He Said Security. And we talk about all kinds of fun things on the show. So thank you again so much for your time today. And I'm happy to open it up to any questions.
Awesome presentation, Jodi. I thought that your actionable tasks that we can take now, those were very, very helpful. So we can just open it up for questions. So just as a reminder, you can place those questions in the Q&A, and we'll give it a few seconds to get started. But to start off, I did have a question, and I wanted to ask, are there certain types of businesses that are exempt from these different privacy laws? Or does it really just apply to everybody who's collecting data?
Yeah, it's a great question. And I promise I'm not a lawyer when I say it depends, because it depends on which law you have to look at. If we look globally, there really aren't very many exemptions. Nonprofits are included, small companies, big companies, they're all pretty much included. Health, financial, it's considered big global privacy laws. Here in the United States, we take what's called a sectoral approach. We have one for finance, one for health, one for email, and we can, one for our set-top box. We can kind of keep going. And what's happening is, as we're creating these new state privacy laws, we're putting, some of the states are carving out some of those. Some states will exempt just the data for health and finance, for example, or Credit Reporting Act. And other states will exempt the whole company if you have to comply with one of those. It kind of depends.
Thank you for answering that question.
Absolutely.
Yes, so I did have an additional question. So right now, what happens to all of the data that you may have collected prior to these privacy regulations going into effect? Is it really just about updating your messaging, or are there different things that need to take place with that historical data?
Historical data would be in scope. The laws aren't really from this point forward. They're kind of everything. And again, kind of depending on the law and the type of data that you have, you might have to adjust the data that you have and go forward from there. That's why you saw a lot of companies in 2018 adjust their email practices, because they had just added everybody to their database, but they didn't actually have the proper basis to be able to do so. We don't quite have the same here in the United States with the US laws. Again, not everything is opt-in. The laws didn't change. So email, for example, is opt-in. It might be a great best practice, but it's not actually a requirement here in the United States.
Thank you. Let's see if we have any more questions. Feel free to place them in the Q&A. We'll give it a few more moments.
And if you don't today, it is perfectly fine. Please do reach out. Would love to hear from you.
Awesome. Well, let's see. I don't see any more questions. And Jodi, if you'd like to flash the contact information, just so people can take a look at that and get their questions to you, that would be awesome. I'm also able to help connect anybody on the call to get in contact with Jodi as well. So with that, in the nick of time, we do have a question. If a citizen of Germany is in Michigan, how do you suggest to treat or collect their privacy preferences?
Sure. So the law doesn't follow the citizen when they travel. The exception to that is if the German person comes over here and now gets added into a marketing database, goes back to Germany, and now you keep marketing to them, now they're covered, which means it kind of depends on your particular business for this poster, but you have to sort of understand where they're from. But when that person, goes to the local ice cream shop and just pays with their credit card, the local ice cream shop now isn't responsible. If they go and stay at a hotel and that hotel captures their information and they're storing it, they're likely going to send that person a receipt. They're likely going to send them a survey that would put them into scope, because they're going to be having some type of ongoing communication with them.
Awesome. Thanks, Chris, for your question. All right. Well, I don't see, yes, you're welcome, Chris.
You're welcome.
So with that, we can close up, but I would just like to thank you, Jodi, for taking the time to present to us today. Your time is very appreciated, and all the content that you shared is super actionable and really timely. So thank you for sharing your expertise today. And thank you for everybody joining. I hope to see you in the new year at the next SDE session. And I want to wish everybody a happy holiday. So thanks for joining today.
Thank you.